You remember a case called ACV, Jefferson County School District?
Yes, Senator.
Were you reversed in that case?
I was partially reversed in that case as well.
Okay. You remember a case called Blake v. United States?
The name sounds familiar, Senator.
Okay. Do you remember being reversed in that case?
I don't specifically recall that particular case.
Okay. Well, I've got others here, cases that you handled in which you were reversed. Tell me why you've been reversed so often, Judge.
What you just watched is exactly why Senator John Kennedy is one of the most effective questioners in Congress today. This wasn't shouting, this wasn't grandstanding, this was methodical, disciplined oversight. Senator John Kennedy didn't insult the nominee, didn't raise his voice, and didn't editorialize. He simply did something very powerful. He read the nominee's own record back to the nominee. I'm Audrey, and this is Congress Lens, where we slow things down, zoom in, and actually examine what happens in these hearings beyond the headlines. If you value accountability, clarity, and straight questions with no political fluff, make sure you like this video, subscribe to Congress Lens, and turn on notifications. Now let's get into exactly why this exchange mattered.
Thank you, Mr. Chairman. Judge, Counselor, congratulations. I want to be sure I understand your records. We'll start with Judge Cruz. Judge Cruz, you handled a case called Vianet Operating Group v. Maurice. Is that right?
That's correct, Senator.
And you were reversed in that case. Is that right?
Yes, Senator.
You handled a case called Moodin v. University of Colorado. Is that right?
I believe so, Senator, yes.
And you were reversed in that case, right?
I believe a portion of my recommendation was reversed, yes.
Okay. Did you handle a case called Vreeland v. Vigil?
Yes, Senator.
And you were reversed in that case too?
A portion of that was reversed as well, yes.
Okay. Did you handle a case called Vreeland v. Olson?
Yes, Senator.
And were you reversed in that case too?
A portion of that was reversed as well, yes.
Okay. You handled a case called Key Bank National Association v. Williams. Is that right?
Yes, Senator.
Were you reversed in that case?
Senator, I've issued over 1,500 recommendations and orders over the course of my 4 years on the bench, and that is one that was partially reversed, yes.
Okay. You handled a case called Renault v. Cardenas. Do you remember that case?
Yes, Senator.
And you were reversed in that case too?
A portion of that was reversed as well.
Do you remember a case called Janney v. Gomez?
Yes, Senator.
And were you reversed in that case?
A portion of that was reversed as well, Senator.
Okay. How about a case, do you remember this case, Judge Schwartz v. City of Denver?
The name is familiar, Senator. For all the cases I've handled, I'm not recalling particulars about that case.
Okay. Do you remember being reversed in that case?
Senator, I'm not specifically recalling that case.
Okay. Do you remember a case called Lucas v. Board of Commissioners of Larimer County?
The name is familiar, Senator. The details of the case are not coming to hand at the moment.
Do you remember being reversed in that case?
Senator, I don't recall offhand at the moment with that case.
Do you remember a case called Brooks v. Colorado Department of Corrections?
Yes, Senator.
Were you reversed in that case?
I'm not recalling offhand if that was one where I had a partial reversal.
Okay. Do you remember a case called ACV, Jefferson County School District?
Yes, Senator.
Were you reversed in that case?
I was partially reversed in that case as well.
Okay. You remember a case called Blake v. United States?
The name sounds familiar, Senator.
Okay. Do you remember being reversed in that case?
I don't specifically recall that particular case.
Okay. Well, I've got others here, cases that you handled in which you were reversed. Tell me why you've been reversed so often, Judge.
Well, Senator, as I indicated, I've issued over 1,500 recommendations and orders over the course of my career. When I approach any of these cases, I approach them all in the same fashion, which is to analyze the law, analyze the Supreme Court and 10th Circuit precedent that bears on those cases, and I apply those cases to the law or to the facts of that case. As a magistrate judge, many of those are recommendations that are made, which are reviewed de novo. I respect the decisions of those district judges who viewed those circumstances differently.
Okay. Thank you, Judge. Tell me how you analyze a Brady motion.
How I analyze a Brady motion?
Yes, sir.
Senator, in my 4.5 years on the bench, don't believe I've had the occasion to address a Brady motion in my career.
Do you know what a Brady motion is?
Senator, in my time on the bench, I've not had occasion to address that, and so it's not coming to mind at the moment what a Brady motion is.
Do you recall the U.S. Supreme Court case, Brady v. Maryland?
I do recall the name of the case, Senator, yes.
And what did it hold?
I believe that the Brady case, Senator, I believe the Brady case involves something regarding the Second Amendment. It is not. I've not had occasion to address that. If that issue were to come before me, I would certainly analyze that Supreme Court precedent and apply it as I would need to the facts in front of me.
Thank you, Mr. Chairman.
Thank you, Senator Kennedy. We'll give Senator Tillis a moment to settle in. He'll be right.
Now that we've seen the full exchange, let's be very clear about what Senator John Kennedy was doing here, and why it was devastating without being disrespectful. Senator John Kennedy didn't rely on opinions. He relied on facts. Case names. Court outcomes. Reversals on record. One after another. This wasn't random, it was a pattern. When you hear a judicial nominee confirm being reversed repeatedly, even if only partially, that matters. Appeals courts don't reverse judges for entertainment. Reversals signal legal errors, misapplied precedent, or flawed reasoning. What makes this exchange even more striking is how calm Senator John Kennedy remained. He didn't accuse the nominee of incompetence. He simply asked yes or no questions and allowed the record to speak for itself. That's a classic courtroom technique, and Senator John Kennedy executed it flawlessly. Notice something important. The nominee repeatedly leaned on volume as a defense. I've issued over 1,500 recommendations. That sounds impressive, until you realize that issuing many rulings doesn't excuse consistent reversals. Experience only matters if it produces sound judgment. Quantity does not cancel quality. Then came the moment that truly shifted the hearing. Senator John Kennedy asked about a Brady motion, not an obscure legal footnote, but a foundational concept tied to Brady versus Maryland, a landmark Supreme Court case every serious judge should understand instinctively. The nominee didn't just struggle with the answer. The nominee didn't know what it was. Even more concerning, the nominee incorrectly associated Brady versus Maryland with the Second Amendment. That's not a minor slip. That's not nerves. That's a red flag. Senator John Kennedy didn't need to say, "This is unacceptable." He let the silence do the talking. He let the nominee's own words create the concern. That's oversight done right. And here's why this matters beyond this one hearing. Judicial appointments are permanent. Senators are temporary. Judges are not. Senator John Kennedy understands that his role is not to be polite at the expense of diligence. His job is to protect the integrity of the courts, and that's exactly what he did here. This wasn't personal. It was professional. It wasn't aggressive. It was precise. And whether people like Senator John Kennedy's style or not, moments like this prove why his questioning resonates with the public. Because accountability doesn't need theatrics, it needs receipts. Let me know in the comments what stood out to you most in this exchange, and whether you think hearings like this are tough enough or not tough enough. This is Congress Lens. I'm Audrey, and I'll see you in the next breakdown.